parameters which we apply for the selection of judges are well defined. First, we look at merit. We look at the professional competence of the judge. We constantly analyze judgments of the High Court judges when they come up in appeal before us. On an average, we are dealing with about 200 cases every week. So those are judgments of the High Courts which are coming up before us, so we assess those judgments. But in the Collegium, we all read the same judgments at the same time. So we circulate the judgments of the High Court judges who are in the zone of consideration. Apart from merit, the second important consideration which we go by is seniority, because after all, this is a service. It's a service. Judges of the High Court are elevated to the Supreme Court. Third important point which we emphasize, that's the need for a broader sense of inclusion. Inclusion in terms of gender, inclusion in terms of the marginalized communities, persons belonging to the scheduled castes and the scheduled tribes, who must have an equal opportunity to aspire for higher judicial and constitutional offices. Apart from the need for including more gender, having a more gender-inclusive judiciary and the marginalized, we also want to bring more minorities into the court. But that is not at the cost of sacrificing merit. Each one of our colleagues who is chosen because she was a woman is as competent as any of her counterparts, the male judges. Likewise for the minorities or for the scheduled castes and scheduled tribes, they're as competent as any other judges we have chosen in the recent past. The next important factor which we consider is the need to have a broader sense of dispersal of judicial office throughout the country. It shouldn't be that judicial office in the Supreme Court is confined to only 1 or 2 or 3 high courts. So to the extent that it is possible, we try and ensure that we give adequate representation to different segments, different high courts, different states, different regions in the country when we are making appointments to appointments to the Supreme Court. We also consult judges who have rooted through that high court and who are judges of the Supreme Courts. For instance, my parent High Court was the High Court of Judicature at Bombay. I was Chief Justice of the Allahabad High Court for 3 years. So when a judge from Bombay has to be appointed, I'm consulted. If I have to be appointing a judge from the Allahabad High Court, of course now I'm the Chief Justice, but when I was a puisne judge, I would be consulted for making, and judges give extremely transparent and clear opinions on what they feel. In the High Courts, it's even broader because the High Courts are looking at lawyers who are fit for appointment, and there are 2 sources of recruitment to the High Court: the district judiciary, and the whole track record of the district judiciary is maintained on paper. You have the annual confidential reports. You have a whole dossier on each judge which is developed as they progress through the service. When lawyers are to be appointed, the same procedure is followed, and there is an equal involvement of various stakeholders in the system. For instance, once the High Court Collegium makes its recommendation, the file is processed at 2 levels. It comes to the Supreme Court, the Government of India, and the Government of the state, so that the Chief Minister of the state, the Governor of the state responds to the appointment which is recommended by the High Court Collegium. At the same time, the file is processed by the Intelligence Bureau to see if there are any adverse intelligence inputs. The file is then, it goes to the Union Government in the Ministry of Law and Justice. The Department of Justice sends the file to us with its annotations. We then consult our judges, after which the file is sent back to the government, and then goes on to the Prime Minister's office and then to the President of India.
The Supreme Court gave an order recently which said that going forward, election commissioners and the Chief Election Commissioner would be appointed in a panel which includes the Prime Minister, the Chief Justice, and a leader of the opposition. So it's not just the government picking the next EC. That is a fantastic idea. Many in government said, but that's also reason why judges should be appointed by people other than just judges. How do you look at all the pressure that's coming your way, saying that the collegium system is not transparent, that this needs to be opened up in a way that judges aren't judging judges, that other people can weigh in, as is the case in many countries internationally?
Right. Now, we have adopted a model. We have a career judiciary. Unlike, say, the United States, where a politician can become, a Secretary of State can theoretically, and you have had Secretaries of State who have become Chief Justice of the US Supreme Court. We don't follow that model. We follow a model of career judges coming to either the High Court from the district judiciary, or career judges from the High Courts coming to the Supreme Court. We, of course, have members of the bar as well coming directly to the Supreme Court as to the High Courts. Since you did mention the issue of transparency, let me emphasize 2 facets. There's a transparency which operates at two levels. Transparency of the process of appointment and transparency in the terms of the choices that you make when you're appointing people. The process has to be completely transparent. And that is why in recent times, we have been putting out onto the internet, onto our website, the Collegium resolutions. And those resolutions tell society at large, our citizens, what are the parameters we have applied in the selection of judges. Let them judge, let them critique us. I'm not saying that any system is perfect, but this is the best that we have developed. And the object of this system, why was this Collegium system divine? It was devised for the simple reason that the independence of the judiciary is a cardinal value. And you have to insulate the judiciary from outside influences if the judiciary has to truly be independent. That is the underlying feature of the Collegium. That's the underlying purpose of the Collegium. But our processes are becoming now transparent. We have defined what the parameters are. We put our resolutions on the website so that people know whom we have selected, why we have selected them, what are the yardsticks that we have applied. Apart from the processes, and this is the most sensitive aspect which I must share with you because a lot of people perhaps wouldn't know about this. When we consider names for appointment as judges of the High Court or of the Supreme Court, we are also dealing with people's lives, particularly in the High Courts. Very often the people whose names are under consideration, we look at diverse set of aspects pertaining to their personal lives, their professional lives, their personal lives insofar as they are relevant to the discharge of judicial duties. I have no cause about somebody's personal life if it has no connection with their judicial duties. But when we deal with these very personal, intimate, sometimes very, very intimate and private aspects of people's lives, we have to be conscious of the fact that you can't, in the process of selection, open up every aspect of their lives to society at large. The consequence will be that good people will then say, sorry, I'm not willing to put my personal life on trial in this particular way. So if you have to have good people, you must also trust your decision makers to make those choices.